All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Please be seated. The Supreme Court of Texas is pleased to be able to hear cases today in El Paso, here on the campus of the University of Texas at El Paso. And we came in yesterday evening and have had a very enjoyable time meeting with faculty and students and members of the local bar. And we're glad to be able to do that. In the 19th century, the Texas Constitution required the Supreme Court to sit only in the city of Austin. And that was the law in Texas until the 1990s, and the Constitution was changed to allow this court to sit outside the city of Austin. And since then, we have sat usually twice a year all over the state, in the law schools, but also on college campuses, also on high school campuses. So we are glad to have this opportunity to see the people we serve, and also to have you see the work that the court does firsthand. So we have two cases to be argued this morning. First is 22-674. It's styled in the matter of a trust, Trust A and Trust C, and it's from El Paso County and the 8th Court of Appeals District here in El Paso. The second case is 22-889. It's Oscar Renda Contracting versus Bruce, again from El Paso County and from the 8th Court of Appeals District. The court has allotted 20 minutes for each side to argue, and we'll take a brief recess between the arguments before we conclude the two of them. So we're ready to begin this morning in 22-674.
May it please the court, Mr. Paoli will present argument for petitioners. Petitioners have reserved 5 minutes for rebuttal.
Mr. Chief Justice, and may it please the court, Henry Paoli on behalf of petitioner Mark Fenenbock. In this case, the words of Bernard and Jeannette Fenenbock, the settlers of the Living Trust, are clear, direct, and unambiguous. In any instance in which two co-trustees are serving jointly, any action of the trustee shall require the joinder and consent of both co-trustees. That's contained in Article 10b-4 of the Living Trust, found at the clerk's record, page 48. This case presents the important question of whether Texas trial courts have the jurisdiction and the authority to ensure that the last words of a settler of a living trust mean what they actually say.
Can I just ask you to make sure that we kind of hone this down? So, am I correct that both parties agree that this is not a jurisdictional issue?
That's correct. Both parties, with respect to the petitions for review that were filed, agree that the 8th Court got it wrong in ultimately deciding that the probate court lacked the jurisdiction to grant the relief that it did.
The failure to join may be a problem in one way or another, but it's not a problem in the sense that it deprived the trial court of jurisdiction.
We would submit that is the case. That's right.
And then, does everybody agree that these shares have to go to the Glenagatti Trust?
Ultimately, with respect to the transfer of the shares at the appropriate time, and subject to an appropriate determination with respect to value.
Sure, value you disagree about, or at least you disagree about your client's right to participate in the process of determining value. But in the end, there's no dispute that these shares are supposed to go to her trust and then to her successors or heirs, right?
That's right. The living trust contemplates that the shares will ultimately go to her trust, with assets of equivalent value being set aside as determined by the settlors on behalf of petitioner Mark Fenenbock.
So if that is the case, that it's uncontested, that those assets should be directed to the Linda Gaddy Trust, why isn't this case simply a lawsuit that determines substantially equivalent value for your client? Why isn't it simply an exercise in valuation so that equivalent trust assets can be transferred to him? Why undo the transaction?
Because allowing the transaction to stand has the effect of unilaterally taking out Article 10b4 of the living trust. It effectively transforms what should have been a joint decision into a unilateral decision.
There's no decision to make. I mean, you agree that it goes to her trust. All these shares go to her trust, and you agree to that. So there's no joint decision to make because you both already jointly agree to that. The only question is what's the value and what does he get in terms of assets to match that value?
I don't think that's entirely correct, Your Honor. The issue here is, yes, ultimately there needs to be a transfer of the shares, but there has to be some determination made with respect to what's the appropriate time frame. When did the shares actually get transferred? Under
That
Article
matters,
10,
but
Section B, that should be a joint decision.
That matters because of the dividends, right?
Correct.
So your contention is that yes, it needs to be transferred, but it shouldn't have been transferred a few days before the dividends were to be paid, the $6 million in dividends, and that should have been part of the residue to be divided, not something that went along with the stock.
That's right, because the living trust specifically identifies the stock as part of the residuary. And because it's part of the
Isn't all of
residuary,
that, I mean, can't experts determine value as of a particular date? I'm trying to understand why you actually need this stock back in the trust to come up with a valuation.
because there has to be some determination made, and the probate court recognized this, that in order for the settlers' words to actually have meaning, there's supposed to be some agreement reached. And if they can't reach an agreement at that point in time, certainly Fenenbock has the right to submit his own valuation expert and opinion and have a legal determination with respect to that. But what happened here was that his rights as a co-trustee were basically invalidated.
So that sounds like a procedural objection. And I'm wondering, we've got a brother and a sister sadly engaged in litigation using an awful lot of the assets that their parents left to them instead of finding a way to do it to pay the lawyers in order to solve it over a procedural dispute. Now, I wonder, can you tell me how it really is different from this? What if the brother and sister had a deal where in successive Fridays, one gets to pick what they're going to have for dinner? And so one of them goes ahead and without consulting the other when it was their turn, orders pizza. And the sister does that. And the brother says, wait, it's my turn. It's my turn. Throw that pizza in the garbage. Okay, well, what do you want? Well, I'd like some pizza. Is that essentially what we're having here? It works out exactly the same. We're going to get the same result. It's just destined that these shares are going to be in Lena's trust. If the problem is that 3 days after the valuation of $3.4 million, there was a $6 million dividend, I get that suggests, well, maybe that valuation wasn't very good. If an asset has a revenue stream like that, probably it was worth a lot more than $3.4 million. But that's something that can be handled aside from throwing out the pizza or restoring the shares themselves to the larger trust. Why is that not the way we should be thinking about this case?
I don't think the court should think of the case that way because it essentially undoes and invalidates what the settlers intended with respect to joint decision-making.
The settlers also intended those shares to go in a particular way. They knew that was going to happen, and you've agreed it's inevitable. So why undo something in order to achieve a procedural process that cannot lead to any different substantive outcome?
Because the substantive outcome can be substantially different depending on two factors. What is the relevant date of the transfer? That Glenna didn't have the unilateral right to make that decision, and what valuation do we apply?
Well, the terms of the trust dictated the transfer. And so, you know, your argument is, well, my client can mutually come to an agreement about that transfer. So are you saying that your client could basically withhold consent to the date of the transfer for 20 years?
No, I'm not saying that. The probate court recognized that the appropriate time for them to make a determination with respect to an attempt to reach an agreement should be after the shares of stock are restored back to the trust. Because ultimately what it does is that by allowing the unilateral transfer without the consent and participation of the co-trustee, we've invalidated the rights of the co-trustee to participate in the decision.
But in a situation where the terms of the trust take away the right of the co-trustee to direct specific assets, what part of the trust agreement should be given more weight? The directive about particular assets being transferred to a particular place, or the more general and less specific directive that there should be, with respect to other assets, joint decision-making?
No, I think Article 10, Section B4, doesn't specifically identify or exclude the shares of stock as something that can be subject to a unilateral decision. And of course, a fundamental rule is that the court has to consider all of the provisions in the trust agreement to determine their meaning. We can't invalidate one section in terms of focusing on another section. There's no limitation in Article 10, Section B4 that suggests with respect to these specific shares of stock that a unilateral decision could have been made. And let me give an example.
Is your client, by withholding consent to transfer these assets in accordance with the terms of the trust, is your client not complying with the terms of the trust?
I don't think so, Your Honor. I don't think there's any question with respect to that. And the reason for that is because the relief that was sought in the probate court was restoration of the shares of stock. The probate court directed the parties to attempt to reach an agreement with respect to ultimately valuation, and if they couldn't reach an agreement, well then Fenenbock was given the right and the opportunity to submit his own valuation. But the appropriate time to make that determination has to be when the shares of stock are restored, because otherwise we're essentially reading out Article 10, Section B4 from the living trust.
So if we agree with you, so number one, this isn't jurisdictional, and then we agree with you that these shares should never have been transferred, and either with or without the sons being joined in some way, the trial court has to undo the transfer of the shares. They go back to the larger family trust. Now's the time to distribute, right? I mean, under the terms, there's no reason why they shouldn't be distributed back to Glenna's trust right now, or as soon as the trial court gets them back into the family trust.
Yes.
Now's the time. And so they're
Subject
going to
to-
be distributed pretty much right away after that. There's no reason for delay after that.
Well, subject to some determination with respect to the co-trustees acting jointly to determine date and valuation.
Okay,
That's
sure.
right.
So, yeah, well, but you say there might be some need to determine date, and I guess if you mean March 2nd instead of March 1st or whatever, but there's no reason to wait till 2026 to do it, right? I mean, under the terms of the trust, they should be distributed back to Glenna's trust. There's
That's
no
right.
reason for a delay on that.
I don't think there's any reason to have any unreasonable length of
And if the delay
time.
matters, if it's going to happen March 1st of 2024 instead of back when it happened before, the effect is the value of the dividends that you were discussing with Justice Busby. Why can't that just be taken care of as a matter of damages?
Because it doesn't fully adequately address the rights of a co-trustee with respect to a right to joint decision-making.
Why not? Because it'll put him right back where the shares will go to Glenna's trust. He'll get whatever money he's entitled to as if they had been transferred on the right date, whatever that may be. I mean, why can't that all be resolved as a matter of damages?
It's not solely a matter of damages because there has to be some determination made as to what is the appropriate date and what is the appropriate valuation.
Sure, but why can't that be done without sending the shares back and forth?
It can't,
Because the reason those two things matter is a dollar number, right? I mean, that's why that matters to your client, both time and value. They are important to your, I get it's also important to your client, just sort of the principle of the matter, that I should have gotten to participate in the decision. But he didn't. So we got to fix that. Why do we have to fix it by transferring them back and forth when the only practical difference is a dollar number? Why can't the court just come up with the right dollar number?
it shouldn't solely be a damages question because damages won't necessarily fully vindicate the rights of a co-trustee to participate with respect to decision-making. It will, to a degree, impact the rights of a beneficiary, and Fenenbock stands in a joint role. He wears multiple hats as a beneficiary, but it doesn't fully vindicate the rights of a co-trustee to participate in equal decision-making.
That
What
sounds
about
like
the fact-
please.
What about the fact that the remedy that the trial court ordered was to restore stock that Glenda no longer owns? Right, so in effect, the trial court is ordering her, requiring her to do something she can't do, or if she can do it, I'd like to know how she might do that. Seems to me as if it's the equivalent of me inheriting a house, deciding I don't want to live in it, so I'm going to sell it to someone else, and then later a trial court comes around and says, give me the title to that house. How can I do that?
Well, keep in mind, Your Honor, we're not at the point currently of any type of contempt or enforcement proceeding. And so our argument in large part has been a lot of those concerns we believe are premature to the extent that Glenn is trying to raise his bona fide purchaser defense.
Why are they premature? It's pretty clear from the Declaratory Judgment Act that the order can't have any effect on the right of third parties.
That's right.
So why can't Glenda just say, I don't have it anymore, so, and this doesn't have any impact on the people who do have it, so, you can't hold me in contempt because it's impossible for me to comply.
Well, with respect to impossibility, there's cases decided from this court that recognize impossibility can't be raised as a defense when the party ultimately causing the impossibility is the person who's responsible for that. We cited those cases in the brief. Specifically, there was the tractor case with respect to the party who attempted to say, well, I don't have to convey back a tractor that I sold to someone else.
Right, yeah, and I looked at those cases, but I guess what I'm saying is why should the court's judgment be read even to have the effect of requiring her to do that, even though it says that, because the law says it can't do that. The law says it can't affect those rights because it only binds the people that are in front of it.
Correct. We believe ultimately the declaratory judgment order at issue and the relief at order binds the parties who are actually before the court. So to the extent that her sons want to raise a bona fide purchaser defense, that issue's never been ruled on by the probate court.
Well, they don't have to raise that defense because you don't have any order for them to do anything. You haven't sued them.
Correct. And
So
ultimately,
there's no need for them to raise a defense.
well, in terms of thinking, going forward, if there is some type of enforcement proceeding in terms of a bona fide purchaser defense, the appropriate time would be to raise that at that point in time.
How could you possibly hold her in contempt if she can't restore the property? Are you talking about holding her in criminal contempt?
No, I'm not talking about a criminal contempt proceeding. When I'm
Well, she
addressing,
doesn't have the keys to the prison in her own pocket if she can't restore the property.
correct.
So it can't be civil contempt either.
Correct. What I'm focusing on with respect to that is that the ultimate issue of impossibility, that's something that was created by the Glenda making a decision that she believes was done in good faith, arguably wrong, we believe, under the terms of the trust. And so should she be rewarded by that conduct by being able to raise that impossibility defense and this arguable bona fide purchaser defense? If the transaction was void, as recognized by cases from this court because it was done without compliance with the terms of the living trust, that impossibility defense, this bona fide purchaser defense, ultimately they're not valid defenses to her conduct, and she shouldn't be able to justify those.
Can I just ask why, if you really want to get the shares back and you know that she doesn't have them and you think you know who does, why not join them? And why have this big fight about whether they're necessary parties under Rule 39, what the consequence of that? Why not just join them in the beginning?
Well, they could have been joined, but ultimately we didn't think it was necessary because they made no affirmative claim with respect to trying to seek some intervention in the case.
But they did make a claim to the property. They bought it.
Correct, but that ultimately is not the final determination with respect to Rule 39. I think Capmeyer addresses that issue partially. They didn't take any affirmative action. to
That's kind of
assert that.
attenuated in Catmeyer, wasn't it? I mean, those are people that might have an interest in whether or not this fee could be raised and whether these particular people had to pay the maintenance. Here, we're talking about the shares. That's it. And they're the ones that you say own them. How is that? That seems worlds away from Catmeyer to me.
Well, keep in mind, the disclosure with respect to the shares being transferred, that was something that was made by Glenna in response to the motion. There was no prior disclosure with respect to that. I think that the focus with respect to Catmeyer focuses on, well, was there some affirmative claim made such that the parties' rights could be affected, even though they had some ultimate right with respect to the proceeding that's at issue? And for that reason, we don't think Catmeyer provides any limitation. If I may reserve the remainder of my time, I don't want to cut you off, Justice
No,
Black.
you'll get your time. I think the other side argues that there's no allegation of improper benefit, and it's uncontested that there are sufficient assets remaining in the trust to cover the substantially equivalent, reasonably equivalent value of the shares. What's your response to that? Because that would be, they say, necessary before you could void the transaction.
Yeah. The improper benefit is that to this day, my client has not shared in any of the dividends or the purchase price that Gaddy received from her sons in connection with the transfer of the stock. Even though under the living trust, he is supposed to receive equivalent value. We've been litigating this case and he's never had a right to receive either of those. And because the stock is part of the residuary, he's entitled also to a right to receive income from the shares. And that's the improper benefit that only Glenna and her sons have received to date. I may reserve the remainder of my time. Thank you.
Excuse me,
Justice Laverne has a question.
I'm still not really understanding your answer to Justice Young's question, because it seems to me that joinder could have just solved all of this.
Well, it potentially could have, but keep in mind, Your Honor, at the time that we filed the motion to declare the transfer void, we had no information whatsoever with respect to the transfer. And ultimately, here we have a situation in which the co-trustee who owes fiduciary duties to Fenenbock as a beneficiary, she has the burden of proof with respect to proving the fairness of the transaction. She has the burden of proof with respect to showing adequate disclosure in order to establish that she did not breach her fiduciary duty. The first disclosure that happened with respect to the transfer was when Gaddy submitted her affidavit or her declaration claiming, well, the reason I cannot comply with the proposed request in terms of the motion that was sought was because I transferred the shares, and that was the first disclosure that was actually made. And that's the reason ultimately here, we didn't seek a joinder prior because it was ultimately not known. Only Glenna had that information. We weren't disclosed about it prior to that point in time.
Any other questions? Thank you, counsel. We'll hear from the respondent.
May it please the court, Ms. Greer will present argument for respondent.
Good morning, Mr. Chief Justice, and may it please the court. I want to clear up one thing. The first disclosure of this transfer occurred soon after it occurred. Mr. Fenenbock filed suit in May.
Why transfer the shares before reaching an agreement about valuation? And if you hadn't reached an agreement about valuation, seeking some determination of valuation on the basis that the trustees couldn't agree to it?
Well, first of all, she had a valuation done by an independent third party.
Right, but there was no agreement about that, and there was no, so ordinarily you would think stock transfers according to the terms of the trust, other beneficiary receives their equivalent value for that stock, but only half of that was completed by your client. And so what do we do with the fact that the transfer occurred, but we still are here today, years later, and there has been no transfer of equivalent assets?
Well, I think Ms. Gaddy fully intended that there would be a discussion that she would present. This was not a unilaterally imposed value. I think that those terms have been used in the briefs. That is absolutely incorrect. Mrs. Gaddy has been inviting her brother to engage in a valuation process for years. We filed a motion under 166G asking for the court to determine the date and determine the value. Set up a process, let us brief it. We've got 3 valuations that we've produced, all completely independent and all completely
What is
independent
the
of each
range
other.
of those valuations?
It's fairly within the same number. It's a valuation of the company, and they're within the same range. Mrs. Gaddy would take any of those at this point.
So let me ask, just out of curiosity, how can there be evaluations at 3.4 million?
3.2. it
3.2
was-
million. 3 days later, there's a $6 million distribution of dividends. That doesn't sound like a plausible valuation of something that has that capacity for a revenue distribution of basically double the entire valuation of the shares.
Well, first of all, the $6 million was a distribution to all the shareholders of this company, W. Silver. The distribution that Mrs. Gaddy made to her sons that they purchased was approximately 32% of the company. Each got about 16%. So they didn't get that whole distribution, and that distribution was a recapitalization that had been planned for some time. It was nothing secret or carried out in any way. And it doesn't matter because Mark was never entitled to that. The stock bequest is a specific bequest. There's no question about that. It meets the test, the long-standing test. It is specifically identifiable as a race. We know that. They've made the same argument in making the constructive trust argument. They can't make a constructive trust argument without an identifiable race. So that's conclusively established on this record. The second part is, did the testator intend that specific asset to go to this specific person? Well, that's conclusively established on this record, too.
It's undisputed. I mean, they said they agree that sooner or later the stock has to go to Glenna.
Exactly, but what
But
they're
it does seem to be
arguing,
disputed about whether the dividend should go with the stock, and that seems to depend on the time of the transfer.
no, not really, Your Honor. That depends on whether it's a specific bequest or not.
The dividend?
Yes, because
Where was the dividend a specific bequest?
or the distribution, because it follows the stock. Under section 116.051, the income follows the specific bequest from the date of death. And there's also the case Hurt v. Smith, which we've cited.
But certainly you could, the income-producing nature of the bequest would be used as part of the valuation to transfer substantially equivalent assets.
Not if it's a specific bequest. It may be, yes, it may be used as part of the valuation. I see where you're going with this. That's correct, but that's a numbers issue. That's a valuation issue. And I think the court's questions, if I'm reading them correctly, are clear that timing and valuation are money issues. They're not equity issues. No purpose is served by having to retransfer and redeposit these shares into a bank account owned by the trust.
Well, other than the formality of saying that trusts need to be administered according to their terms, and that they're making, it is a procedural argument. I agree. It seems like we can get to the same financial outcome, but there is something to be said about the idea that trust must be administered properly.
Absolutely, and there's an answer to that, because as the court is aware, Mrs. Gaddy had no idea that her brother would claim to be a co-trustee. His claim is based on a First Amendment, to the trust that we interpret differently, quite frankly.
You didn't appeal that, right?
It's not, it's
She
interlocutory.
no longer disputes that, though? She now no longer disputes that he is and should have always been a co-trustee?
I don't know if we might take that position after final judgment. It may be moot at that point as a practical matter.
She certainly doesn't concede it, but she's not disputing it at this point.
We're not disputing it for purposes of this appeal. We're trying to make it as simple as possible. So assuming he is a co-trustee and he has an equal right to consent, that consent may have been violated because she was unaware that he was a co-trustee. I mean, that's clear. She had no idea. There's no evidence in this record. That came after the fact and when he filed the lawsuit. And so she did it thinking she had the authority and the power to do it. If it's wrong, if it's defective, that's a question of voidable, not void. And this trust section that they're going under deals with, not the trust, the statutory provision they're going under, 114.008, deals with void orders. The order says this transaction is void. Well, void means it's incapable of ratification. This court recently, touched on that issue in Concho Resources versus Ellison. Void is incapable of ratification or acquiescence. Well, that's not how trusts work. Under the restatement third of trust, which both parties rely upon, section 39, an action of a co-trustee can be ratified by the other co-trustee. And as we've pointed out, Mr. Fenenbock has a duty to agree to the stock transfer. he will be in breach of his own fiduciary duty as co-trustee if he does not consent to this transaction. So
Is
his
your position
withholding.
that he has a duty to do that before there's an agreed value?
I think it is, because I don't see that the agreed value is necessarily tied to when the stock gets transferred. The reason she
Well, but
did
it
it,
might be because he's supposed to receive reasonably equivalent value. Why wouldn't that be at the same time?
well, ideally it would be, and that was certainly her intent. She was going to she presented him with the valuation.
Well, it's very
And-
different to say, I present you with a valuation than when you've got two co-trustees who are supposed to be working together to do that.
Again, she did not know he was claiming to be a co-trustee at that point. She had no idea. She's the sole executor under the
Right,
will.
well, but I don't understand why it would matter what her intent was for purposes of any of this.
Because it had already happened.
But that doesn't affect whether there was a violation or not.
Well-
It's not a scienter standard for whether there's a violation, right?
No, but the point is it can be ratified. I mean, Bogert, one of the treatises that we both rely upon, says, quote, when a single trustee seeks to exercise a joint power, the invalidity of his action may be cured by a later, and this is an emphasis in the treatise, ratification or acquiescence by the non-acting trustees or by court order.
It sounds like he's not agreeing.
And that's might be why we have to go to a court order. We're trying to engage the process. We've done everything we can to present.
One thing you could have done would be to have joined Glenna's sons. That didn't happen from their side, didn't happen from your side. If
They're
that
not-
had happened, would that not have simplified things considerably?
No, I don't think it would, because they're not, from our view, the stock shouldn't have been ordered retransferred. They're not implicated by this, and they shouldn't be implicated by this. It wasn't her job to bring them in. They wanted this extraordinary relief of a mandatory injunction that has no precedent, and that it was their duty to do what it took to get that relief
If
and
they
show
were
equity.
right, though, if they were right that the sons had to, well, let me back up. On this joinder issue under Rule 39, I'm right that both parties agree that's not a jurisdictional issue. If they should have been joined and weren't, that did not deprive the trial court of jurisdiction. You agree with that?
Absolutely.
Okay. And so then, but let's assume that they should have been joined, they claimed an interest, or for whatever reason, or maybe under the Declaratory Judgment Act, they should have been joined. And so now we have to decide, what do we do with the fact that there was this determination made without them there? So we all agree it doesn't bind them, all right? You agree with that?
Well, if the yes and no, I mean, if Glenna Gaddy can be held in contempt of court because she can't do what the court has ordered, then I think, or if the stock is somehow restored, they've been deprived of their rights. I mean, it's really strange how the court.
Let's break it down into distinguishing between declaratory relief and injunctive relief. Certainly, the trial court could declare that the shares, that the transfer was either void or voidable because he was not permitted to participate as a co-trustee, and that would be a binding declaration as to these two parties, but would have no effect on the sons.
Well, I disagree with that, Your Honor. It has a practical impact that is significant, and that is that it is creating uncertainty over 32% of the ownership of a successfully operating company.
Well, then parties have to figure out some way to get to court to resolve that uncertainty. For whatever reason, these two parties don't want to bring them in to do that. So if the sons care enough about the uncertainty, they would have to file their own lawsuit so they could finally be bound.
Well, it's our position we don't even get there because it's an issue of valuation. And all we need to know is the date. Again, we've asked the probate court for the date. We've asked the court to make its own valuation, appoint a court-appointed expert. Whatever it's going to take to get this number, Mark will not engage. He has never even provided specific criticism of any of the valuations that have been provided by these third parties, including a judge.
Why not affect a transfer of one of the valuations, even the lowest valuation that you've received? Why not affect that transfer?
I mean, Mark, if Mr. Fenenbock would agree to that. I mean, so far we haven't been able to agree on anything because their position is until the stock is retransferred, And again, this is almost 7 years since these transactions occurred, and we are just now at this point.
Why isn't there independent value apart from the money in vindicating the parents' desire that the children administer the assets together?
Well, there could be independent value in that, but the point of that is it's solved by ratification, because ultimately Mark has to agree to this transfer.
So I think your point on ratification is not that he's agreed, but because the transaction can be ratified, it's a voidable transaction, not a void one.
Correct.
And I think their response to that is, under the trust code, there was an improper benefit because Lena retained benefits associated with the transfer of the stock without conferring onto Mr. Fenenbock the reasonably equivalent value of that stock.
Well, with all due respect, Your Honor, that's a self-inflicted wound, because we are prepared to agree. We have tried to agree.
So your point is you can't withhold agreement in perpetuity and run up the damages or the value associated with the transaction.
Correct, and hope that the company continues to be more and more successful and try to pick a date where he'll get more of the equivalent value.
But that sounds like a claim you would have against him for breach of fiduciary duty. Have you brought that claim?
Not yet. We're trying to get this resolved, because what Mrs. Gaddy would want most of all is to wind up her parents' estate, her mother's estate, as her mother intended. And
But that's not before us or any court at this point, whether consenting or withholding consent was a breach by Mr. Fenenbock.
no, it's not before the court. We're just trying to get evaluation, because we feel like if we could get evaluation, we can hopefully wind up there are only two major issues
But
left.
that issue, compelling evaluation, is also not before us.
It's not before you. It's before the probate court, but everything's been stayed pending the outcome of this appeal.
If we agree with both of you that this is not a jurisdictional issue, the joinder problem is not a jurisdictional issue, we never get to fundamental error issues here?
Correct.
Okay.
With respect to the parents' intent, it seems to be the case that the intent was for the siblings to work together. And one might gather from a trust that's set up that way that the parents were more concerned that their children work together than they were about who got what. And so I'm concerned in this case about a rule that would encourage litigation over the assets as opposed to maximizing the incentive that the courts give people in this kind of a situation to work together.
I understand that, Your Honor, but the point is, sending the stock back to the account accomplishes nothing. It's not a void transaction. It's voidable at best. And so it can be subject to ratification by the court, and that may be the next step we need to take when we get back to the court, is to get ratification through the court or Mr. Fenenbock. And so, you're talking about a nuclear response to something that should be fixed by a proper jurisprudential procedure in place, which is to basically come up with valuations, and then the court may have to pick or appoint its own court-ordered appraiser, as Judge Villa did in the other Fenenbock case brought by Mr. Fenenbock's daughters.
Does the terms of the will or the trust agreement, did they become effective upon the death of their mother? And so was Mrs. Gaddy's entitlement to the specific bequest of stock, was she entitled to that immediately upon death, or was there some timing?
Yes, Your Honor.
In either the trust or the will?
According to the trust code, she was entitled to it at the time of Mrs. Fenenbock's death, which is why there's no issue really with the dividend, because she acquired the asset at that point. And so this was just a formal transfer of the action.
Did it vest automatically, or was there some action required?
The trustee was to transfer it, but it has to do with tax purposes. There are aspects of it that vest at the death. And then there are aspects of it where the transfer had to occur, which is why it occurred the way that it did.
So what would the tax consequence be of saying that the trustees didn't have to agree to transfer it?
I don't know that there would be a tax consequence. The tax consequence is that Mrs. Gaddy and whoever owns the asset would be liable for any tax on the distributions or income after the date of death.
One aspect of this case is this impossibility, the idea that it's impossible for her to perform what is commanded, restore these shares. So I wonder, what if instead of it being shares in a company, it was a Ming vase, and the allegation was, well, she took the Ming vase, and that really was something that we had to decide together, and et cetera, et cetera. And the court said, yeah, return the Ming vase. And she says, I'd love to, but last week the dog jumped up on the table and it smashed into dust. Here's the dust, that's all that's impossible to perform at a certain level, aside from giving it to some other person. What would the law do in that situation?
Well, I mean, I would argue that you wouldn't be subject to contempt, but the problem is this is a lot more murky because of the way that it's been argued and presented to the trial court. And I don't think that it's unclear as to who is to restore it. So we have a double problem in this case. It's not just the order that you're talking about, return the Ming vase. We've got a who is to return it, who is to restore it.
Let's just assume, for purposes of this perhaps silly example, it was Glenna who took the Ming vase, she put it in her own trust, and then she put it in her house. She's supposed to return it to the archivist that maintained the family property or whatever, so they could together decide what to do with it. And my assumption is, well, if the vase has been destroyed, there's no way she can comply with that. It's literally impossible. But it's not impossible to say, well, we can get a bunch of fine art appraisers to say what the value of the Ming vase was at the time that she wrongfully took it, and that must be presented to the court or to the trust or whatever in exchange. Is that not the kind of thing that would happen, even if assuming, yes, it was wrongfully taken, I should restore it, but I can't. For whatever reason, I just cannot do it. I don't have it. Is that not how these problems would be solved generally?
I think that would be the right way to solve it. Again, it's a question of valuation, and especially when the parents made it very clear that was exactly the way it was supposed to happen. Glenna got the stock, he's to get a reasonably equivalent value. All we need is a date and valuation to be decided by the probate court if the parties can't agree. And we've been trying. We would like to resolve this, but you're right, there is an impossibility, and whether it was imposed by Glenna or on herself or not, we don't even really get there because there's no purpose in ordering the unraveling of all these transactions. Nothing's to be served. It's all going to have to be done right over again. And, again, there's more than enough assets. I want to make it very clear, the last appraisal or inventory of the estate had it appraised at more than $5 million. The trust has at least that much in it. So there's more than enough money based on any valuation that Mark might come up with.
What if it were $6 million? What would happen if the shares were worth more than the rest of the trust?
I think you would have a different situation. There might be a remedy and damages against the trustee. I'm not really sure. The beneficiary would need to be made whole, but we don't have that problem here because the will pour over into the trust, and that $10 million plus will be is pretty much liquid because Ms. Gaddy has done a great job of handling the executor duties.
Any other questions? Thank you, Ms. Greer. Mr. Paoli, you have 5 minutes.
One point I want to emphasize to the court is the court has petitioner's oral argument exhibits. Tab 1 contains a contrast between what parents, Bernard and Jeannette, did when they identified specific gifts versus a residuary gift. And tab 1 shows the court that Bernard and Jeannette, in their will, specifically knew how to make specific bequests. They titled them specific bequests to Glenna, specific bequests to Mark and Glenna. But then with respect to identifying the W. Silver recycling stock, the settlors and the testators specifically chose different treatment. They identified it under the title residuary bequest. They identified it by describing the trust remainder in equal shares as including the W. Silver recycling stock. I think that exhibit shows the court that, contrary to my able counsel's argument on the other side, the W. Silver recycling shares of stock were not a specific gift. They were a part of the residuary. And under 116.051 of the trust code, because they're part of the residuary, Fenenbock has a right to share in the income that is paid in connection with that
Right,
property.
but does he have a right to withhold his consent to the transfer with the idea of waiting for years for the value of the stock to potentially increase in value before effectuating the transaction? In other words, just, you know, it inures to his benefit to withhold and see if the stock goes up in price.
Your Honor, quite frankly, I
And
don't.
then, and then can argue, oh, if it went down, you could argue, oh, no, I get the valuation at the date that, you know, at the date of our mother's death. If the stock goes down, if the stock goes up in value, I get the valuation at the date of death plus all the value that's been captured while I haven't agreed to the transaction.
Your Honor, that's not what my client's trying to do.
Okay.
There's been no attempt done to do that. The reason why
And
we're
there's no
delayed.
claim- There's no claim against him for that, right?
Correct. There's no active or asserted claim in the case. There's nothing in the
But
record
just
to
in
indicate
terms of
that is a claim.
valuation and damages,
I'm sorry?
just in terms of valuation and damages, you know, there is a sort of wait and see what happens.
That's correct, Your Honor.
Unless you fix the date at the, you know, at the date of death.
Correct. And ultimately, part of the reason we're here is because the court system has gone on, and, you know, as the appeal has been prosecuted. It's not a question of my client trying to just sit back and say, well, I just want to wait around forever so that the value of the stock in the company goes up, and then
So
therefore
even
we need a
though-
determination with respect to that.
Even though the determination that he is a co-trustee is not been reduced to a final judgment, do you concede that at this point your client has an obligation to act as a fiduciary and to protect Glenna's interests?
Yes, in his role as a co-trustee, I will disagree, I think, with my able counsel's argument with respect to whether that is an appealable probate court order under the De Ayala test. I pointed that out because I think that ultimately, that determined that discrete phase of the proceedings, and there was never an appeal filed in
So you
connection
think
with that summary
you think it
judgment.
is final?
Correct. I do think it is final. It's not reduced to a final judgment in the traditional sense, but of course, in probate courts, we have a different standard that applies under De Ayala.
Okay. And,
Do you-
so your client at this point, you think, needs to act in accordance with those duties, and do you perceive some risk for your client in not agreeing to move the process forward in terms of coming to the table with evaluation?
No, I don't think so at all, Your Honor. And the reason for that is because what the probate court contemplated here is that in order to vindicate Fenenbock's rights as a co-trustee, we need to restore the stock. And ultimately, that's the appropriate time to make a determination of value. The fact that multiple years have passed, ultimately since the valuation, since the transfer occurred, that's ultimately just a part of the court system, and the fact that there are some significant legal issues in the case that both our El Paso Court of Appeals and now this court is ultimately trying to address.
What about the Ming vase example I asked your friend on the other side? If that was what needed to be restored because your client did not have the opportunity to participate as a co-trustee, but it's just a big pile of dust and rocks at this point, what do you think would happen then?
I think in that limited example, if there's ultimately impossibility because the ultimate property is no longer subject to being restored, in that limited example, then you would probably just have a claim for damages.
And so that impossibility was also caused in the same way that the impossibility was caused in this, to the extent there is any, by Glenna.
I don't
Your
think
argument
so.
is we have cases that say if the defendant is the one that caused the impossibility, we won't entertain that argument. And so if what she took were the shares causing the impossibility, took as the vase causing the impossibility, you're saying we can entertain impossibility if it's a Ming vase that's destroyed, but not if it's shares that have now been sold and resold and resold.
Yeah. Your Honor, I think the example is a good one in contrasting. There's a difference between an accident and a person making a conscious decision to do something that puts them at risk of violating a fiduciary duty that they have the obligation to prove. This case is the first situation or the latter situation. I think your example ultimately arises from a situation in which a person literally has no control over the impossibility that's
But
created.
they are the ones that took it out wrongly. That's still at least a but-for cause, but you're saying it's severed because of the dog jumping on the table.
That's right.
Can I ask you one last thing, for me at least? Given that the parties agree, and if the court agrees that the Court of Appeals was mistaken in its view of subject matter jurisdiction, should we just remand it to the Court of Appeals and say, look, you thought you didn't have subject matter jurisdiction, we can now confirm that you do, so proceed and resolve the rest of the parties' dispute without this court taking any view on any other question or not?
I think that's a possibility, Your Honor, but I don't think that's appropriate here. In many of the cases that the court addresses in the context of fundamental error, you have courts of appeals ultimately not addressing the merits, and then ultimately when it does come to this court, the court actually does address the merits because the fundamental error analysis was not appropriate. I think under Rule 60.2b, that rule contemplates that the court can reverse the lower court's judgment in whole or in part and render the judgment the lower court should have rendered.
I don't dispute that we have the discretion to resolve the merits, but given that the Court of Appeals has not reached any of them and there's all of this murkiness between the parties, would it not be wise for us to allow the Eighth Court to do that?
You know, I think the simplest answer to that question is I think both parties, after multiple years of litigation, I think this process has now gone on for about 7 years, they ultimately do want a determination on the merits. And at some point
I see
in
a
time,
head
that
nodding
needs
on
to be
the other
addressed.
side, yes.
That's right.
That's not me. Okay.
If I may, Chief, just one follow-up. Do you agree with the respondent that if the transfer was inappropriate, as your client contends, that it makes it voidable as opposed to void?
No.
Okay, and could you just give us the citation to help us know the right legal answer to that question?
Correct. It's two things, Your Honor. It's Section 113.085 of the Trust Code, which contemplates that co-trustees may act by majority decision. And secondly, it's this court's decision in Slaughter versus Qualls, 139 Texas 340. That case recognized that a trustee who sold real estate under a deed of trust that was contrary to the actual authority granted by the deed of trust did not convey good title, and that transaction was ultimately void. And so if the court is going to consider and vindicate the rights of a co-trustee, I think those are the two most relevant authorities to consider.
Any other questions? Thank you, Mr. Payola. The case is submitted, and the court will take a brief recess.
All rise. I also want to let everyone know that after this argument, there will be a question and answer session. And there is a microphone set up here on the left-hand side. After the argument, you can form a line if you want to ask a question. Keep in mind when you're thinking about what question you might want to ask that the court won't be discussing the merits of these cases that you heard today. They'll be doing that later on in a private conference. So you can't ask them how these cases are going to come out or what they thought about the arguments in these cases. But there are no bad questions. So we encourage you to participate in the question and answer session after the argument is over. All rise.
Please be seated. The court is ready to hear argument in our second case, 22-889, Oscar Renda Contracting versus Bruce.
May it please the court, Mr. Anderson will present argument for petitioner. Petitioner has reserved 5 minutes for rebuttal.
May it please the court. 41003D of the Civil Practice and Remedies Code mandates that punitive damages may only be awarded on a unanimous jury findings on underlying liability, gross negligence, and the amount of punitive damages. Obtaining those affirmative findings is clearly the plaintiff's burden, just as it is the plaintiff's burden to satisfy the requisite elements.
Was there an instruction that, with regard to exemplary damages, that it had to be unanimous?
Yes, there were instructions on question 7, which was the first. It was the gross negligence question.
No, I think it was 8, was the one about what sum of money should be awarded for exemplary.
There was not a specific question as to 8, other than that the jury was instructed that in order to answer question 8, they first had to answer question 7.
So was there an objection to that?
Neither side made an objection to that. That was overruled.
So does that waive it then, because you have to object to any error in the jury charge?
First, I don't think it was Oscar Renda's burden to object to that, because that finding is necessitated by 41003, and it is part and parcel of the plaintiff's burden. And the respondent homeowners were not only the plaintiffs in this case, they were also the appellants. They are also the party that challenged the judgment. And in addition to that, they were the party that stood to benefit by having those positive findings. Now, that's a bit circular, but that's the fact. They were the party that needed that. If the charge is defective, that's going to prevent them from getting the verdict that they want.
Go ahead.
Yes, ma'am.
Did the charge itself, it seemed to follow the Texas pattern jury charges, except about maybe 2/3 of the way down, the sentence that instructs the jury that they must be unanimous on the finding of punitive damages is deleted. Is there any understanding of how that happened?
I think you're referring to the absence in the instruction on before question
Right,
8.
and that it otherwise tracks the pattern jury charge exactly, it just removed that.
I was not the trial counsel on the case, so I'm not in tune with specifically how that happened, and I don't think the record makes that super clear either.
So I think the Bruce's rely on the Osterberg case that says that if there's an unobjected to error in the charge, the sufficiency of the evidence should be evaluated according to the charge as given. What is your response to their argument that that law applies here?
First of all, I think that the party that is going to suffer the most harm if it's applied as given is the respondents. Because if you look at the charge, in Osterberg v. Peck and several other cases say that you look at the common sense wording of the charge and then in the context of the case. But the common sense wording of this verdict is that the jury certified that their verdict was not unanimous and that only 10 of 12 had answered yes to every question. And so that's the verdict that the respondent homeowners have to live with. And the second part of your question, one distinction in Osterberg and all these other cases that say that you have to live with the judge, or the verdict and the charge is the way they are. Rarely in those cases does it align so perfectly where one side has the burden of proof around every turn. In this case, the homeowners, the plaintiffs, they're also the appellants, and they're also the ones challenging the verdict, or rather the judgment. And the verdict that they needed is the charge that they failed to object to. They failed to secure the questions they needed to get the answers they wanted.
So your point is that the trial court on this question ruled for you, and so you have the shield of the judgment and any reasonable basis for affirming it, as opposed to the case in which you made the arguments that everybody's making right now to the trial judge, and the trial judge ruled against you.
Yes, I think that's a fair summary of our position. But in addition to having the charge, the judgment, we also have the only definitive answer as to unanimity, and that is that the jury answered yes, only 10 of 12 on all questions.
So you're happy to take what the charge says because it says only 10 answered yes to that? Or at least it doesn't conclusively show that 12 answered yes?
There's nothing definitive to indicate that any of the jury's answers were unanimous, other than the simple fact
Well, what about question 7? It says only answer the gross negligence question if you're unanimous. Isn't that an indication they were unanimous on that question?
It's the United Scaffolding versus Levine case that says that you assume that the jury followed directions unless the record demonstrates otherwise. And that's exactly what we have here.
Well,
Fine,
but
go ahead.
isn't the record unclear about that? Because we really don't know what happened in terms of, right?
There's nothing other than just speculation that the jury answered any of those questions in affirmatively, other than the fact that they answered question 7.
Well, why isn't that good enough? Because it doesn't seem contradictory to the certificate, which says 10 of us have agreed to each and every answer. So it could be true that 10 agreed to each and every answer, and 12 agreed to the answer on, both of those things can be true, that 10 agreed to all the answers, and that 12 agreed to the answer on whether there was gross negligence, right? Those don't contradict each other.
Well, you're right, they don't directly correct or contradict one another, but there's no definitive showing. And,
Well,
and it's one assumption that follows a second assumption in order to reach that conclusion.
But don't we have to reconcile the verdict in favor of the jury's findings?
I don't think that you do.
I thought your point was more that we can't do that on question 8, which is the amount of exemplary damages, because there's nothing to indicate that that was unanimous, because the conditioning instruction was missing, saying only answer if you're unanimous.
Right, maybe I misunderstood the import of your question. Do you have a follow-up?
I think I understand your argument. You can go ahead.
Okay. So, I mean, that's it in a nutshell. The burden on every turn here was on the homeowners. They didn't satisfy that burden. The only definitive point that can be determined without going into assumptions is that the verdict was not unanimous. And on top of that, I think that the certification holds special significance, particularly when the mere fact that they took the act of answering question 7, that's not a finding. It's incidental to
What case says that's not a finding?
Well, I think that's just common logic.
It says only answer if you're unanimous, and they answer, you think that's not a finding that they were unanimous?
I don't think it's anything as high of the degree as their answer on the certification, which is what...
The certification addresses this. Rule 226A says very clearly how you're supposed to do this, and it just doesn't seem to have been followed.
Well, and that's because of the defects in the charge, which are certainly not attributable to Oscar Renda. Oscar Renda didn't have the burden on any of these matters. And I think by extension, the court's ruling in a similar case, Zaria versus Aitko, that was a companion statute, 41008. And I understand that it was a different issue. It had to do with whether the caps on punitive damages constituted an affirmative defense. Nonetheless, it's instructive because the court specifically found, and the language is very interesting, it's a fundamental principle that 41008 does not impose a burden of proof on the defendant. It certainly doesn't in 41003 either, and particularly not when the judgment is in Renda's favor, and Renda's not the appellant. And so when we come down to preserving error, that's got to be fairly on the plaintiff and the appellant and the party challenging the judgment. And the language of these cases say that again and again. On top of that,
do our omitted element cases bear on this at all? Because we've said, you know, if a plaintiff submits 3 out of 4 elements of a cause of action and gets a finding on that, and the defendant doesn't object, then the missing element is deemed found by the jury. Is a conditioning instruction like that, not like that, in terms of how many votes you need? Are there any cases that shed any light on that?
I don't have an answer to that, Your Honor, and perhaps I could answer that in a letter brief if that would help the court.
If you find some helpful cases, but if not, it's just trying to figure
It's
out
an
how that
interesting
fits with
question.
some of our other charge precedent.
Yes, and of course, that's not an issue that came up in the briefing, and it's not something that I felt that I was at liberty to bring up. I would like to be able to answer your question, but unfortunately...
If you have something helpful, you're welcome to submit a letter, but if you don't find anything helpful, don't feel that you need to.
Thank you.
As to questions 1 and 7, I'm inclined to think that it is established that those were answered unanimously. We decided last year in Rudolph Automotive that jurors are presumed to follow instructions, and the burden on someone who's going to show otherwise is to show something in the record that they didn't. And I'm not sure that the answer that you have given, that they've certified that 10 out of 12 signed the entire verdict, dislodges that presumption. So let's just assume for the moment that I'm implacably going to assume that 1 and 7 were unanimous. What is your best answer as to why 8 was not?
there's nothing in the record that indicates that it was. That the instruction that the plaintiff needed, the plaintiffs, to get that response was lacking. And that's...
That distinguishes 1 and 7 pretty clearly, right? Question 8 did not have that instruction, so the jury could go ahead and answer it, not be unanimous. Nobody asked them to be unanimous, and they went ahead and signed the certification as to 10 and 12, meaning that, yeah, we all answered 1 and 7, maybe some of the others, but not all of them. And that's, the colloquy you've been having, I think it's possibly as simple as that. Is that your argument, or am I making up an argument for you?
I think that to the extent that it's Renda's burden to show in the record that it's not unanimous, despite the fact that there's not really any definitive evidence of it. The only other thing that I could point to would be the polling of the jury. I understand that that's repetitive of the information that we already have through the verdict, but it is cumulative, and that's got to be at least some value. And again, at the end of the day, another point is that 324B, Rule 324B, it allows an appellee to preserve error through a cross point. And cross points, of course, are determined liberally. They don't have to be labeled cross points. And then it goes on further to say that anything that would vitiate the verdict is effectively preserved in the same way under Rule 324. And so I feel that Renda has preserved its arguments.
Would you just clarify for me, did your client's trial counsel object to questions 7 and or 8 on any ground at all?
Trial counsel objected to the instructions as a whole based on the argument that there was insufficient evidence for those matters to be submitted.
But that was the only basis on which they objected to 7 and 8, was insufficient evidence?
There were no other objections by any party.
Could you spend a minute talking about, you're not challenging here the jury's finding of negligence, but you are saying there is no evidence in the record to support the finding of gross negligence. And those 2 points seem at least to be a little in tension, right? You're not challenging negligence, but what is your best argument about why, conceding that there was some evidence of negligence, why that can't rise to the level of gross negligence? Is it more to do with the subjective component or the objective component?
The arguments that were raised in Renda's briefing, which in fairness, I was not the author of those briefs, so I'm not quite as familiar with all those factual arguments, but I will acknowledge that that your argument has some appeal. So,
but you don't concede.
There's evidence
to support gross
I'm not in a position to concede that, but the factual and legal sufficiency arguments, those are not our most important arguments.
Any other questions? Thank you, Mr. Anderson.
Thank you.
We'll hear from the respondents.
May it please the court, Mr. Gray will present argument for respondents.
Mr. Gray, we're getting a little ringing in here. You might pull that microphone down just a bit.
Absolutely.
Yep, great.
Chief Justice, and may it please the court. My name is Garrett Gray on behalf of the respondents. The judgment of the 8th Court of Appeals should be affirmed for 2 independent reasons. First, Renda Contracting has not and cannot show the jury was not unanimous in reaching its gross negligence finding, giving the trial court no basis to set aside the jury's verdict. And second, Renda Contracting has failed to preserve any error or any alleged conflict in the jury's findings. Justice Busby, you asked about cases from this court dealing with charge error and preserving error that might be instructive, and I think there are a few that this court could look to, starting with Burbage versus Burbage from 2014 from this court. You have Ramos versus Frito-Lay Incorporated, as well as American National Petroleum Company versus Transcontinental Gas Line, corporation. And in all three of those cases, there was either an omitted instruction or an omitted question of damages on a theory or an element. And this court reasoned under Rule 279 that when a theory is submitted to the jury and there is an instruction or an element missing, the burden is on the defendant to object to that error in the charge in order to preserve
that
error.
gets to the preservation issue, which I thought was your second point. I'm interested in hearing first, your first point is, on what basis could we ever assume or treat as if that the jury was unanimous on question number 8?
So as to question number 8, admittedly there was a defect there. It was missing the unanimity instruction as to the amount of exemplary damages. But because that was not preserved and because of what this court has said in case.
So as to your first point is, as to question number 1 and 7, we can just look at the charge and can assume, in fact, must assume that the jury followed the instruction. They didn't answer, because they answered 7, they must have answered 1 unanimously. That's what the instruction said. And then they only answered 7 if they were unanimous, and so I get you there. But you do agree that with regard to question 8, the amount of exemplary damages, there's no basis on which we can assume that was a unanimous decision.
Correct. There's not an entire basis to assume that. Now, question 8 did tell the jury only answer this question if you answered yes to question 7. Right. So in order to get there, they had to be unanimous.
Well, no, they had to be unanimous on 7.
Correct.
But there's no basis to think that they were unanimous on 8.
Question 8 is lacking the unanimity instruction, yes.
So then we get to your second point, which is, however, they didn't preserve that objection.
That's correct. And additionally, in Renda Contracting's briefing to the Court of Appeals, they don't challenge question 8 at all. And additionally, they refer to any error as to question 8 as harmless.
Well, it sounds like they're happy to accept question 8 as it was rendered because it's a 10-2 verdict on the amount of exemplary damages, and the statute says you have to be unanimous both as to whether you can get exemplary damages and as to the amount of exemplary damages, right?
Yes, Justice.
Okay, so why can't we just, I guess, it was defective because it doesn't get you what you want, but in itself, there's nothing wrong with the question, right? I mean, it's fine as it is, it just doesn't support the relief that you want, I think is their position. So why is that wrong?
It's wrong because omitting the unanimity instruction is essentially akin to omitting an element, for instance, in which there was no objection ever to omitting that instruction or that requirement, and this court can essentially, because it was never challenged, deem it. But then we would look, if we had a deemed finding case like that where an element's omitted, then we go and look at whether there's any evidence to support the deemed finding. And so what would you point us to as evidence that the jury actually answered question 8 unanimously? As to evidence that the jury answered question 8 unanimously, I think you would look first to the instruction on question 8 to only answer question 8 if you had answered question 7 yes, which means that the jury up to that point was unanimous. But admittedly, that there's not much after that to do.
Yeah, I mean, if here, I guess the way to think of it, if there was a question 9 that says, is the sky blue? The jury says yes. Do they have and then the trial court says, I'm going to award $1 billion because the jury said the sky is blue. Well, that's no legal basis to award anything. Did they have some duty to object to the question? I mean, to me, that's what their argument is here, is look, you can ask all day long if 10 of you think that $75,000 per plaintiff is the right amount of exemplary damages. You can ask that all day long if what 10 jurors think. We don't care. Go ahead, do it. We're not going to object because whatever answer you get doesn't give you an amount of punitive damages. That's their argument. Why is that wrong?
It's wrong when looking at, for instance, Osterberg, which says the charge submitted to the jury is what controls on appellate review. And so this charge here.
The sky blue. That's the charge submitted. I mean, okay, you can submit it, but I don't have to object to it. Get all the irrelevant answers you want.
In connection with this idea that we have to look at the charge as submitted, does it matter that the Civil Practice and Remedies Code, which has a whole section devoted to particular standards of proof and requirements to get punitive damages, which are to punish someone as opposed to compensating someone. In the Civil Practice and Remedies Code, it says that each of the elements, including damages, must be unanimously found. And it says, this burden of proof may not be shifted to the defendant. What do we do with that? Is this idea that it could be deemed against the defendant really then shift the burden to the defendant?
No, I don't think that's a shifting of the burden, because in any context, I think this court has always found that when a theory of liability is submitted to the jury and there's a defect or an omission, there's always the burden to object and preserve error. And if that fails to happen, the charge submitted to the jury is what controls on review. And so I don't think there's any shifting of the burden here. The burden absolutely is on the plaintiffs, or here the homeowners, to procure the finding.
And then in connection with this idea of the burden for objecting, the cases that you cite, and usually the way the cases come to us is that the defendant has lost that issue in the trial court. So in order to preserve error, the defendant had to let the trial court know, hey, wait a minute, the verdict's not unanimous. In this case, though, the defendant won this point in the trial court. The trial judge agreed this is not a unanimous finding on the amount of damages to punish the defendants, and didn't enter judgment. So how do preservation principles come into play? They don't have an error in the trial court's judgment that they seek to preserve. They like the trial court's judgment with respect to punitive damages, at least.
Preservation of error comes into play with how we got to this judgment in the first place, which was after the jury was already discharged and after the homeowners had filed their motion for entry of judgment. For the first time, Renda Contracting wanted to rely on what they assert as a conflict in the jury's findings. But looking at this court's plurality opinion and Menchaca, as well as in Los Compadres Pescadores and in Ray Rudolph, if you are going to rely on an alleged conflict in the jury's findings, that needs to be raised before the jury's discharged. So I think
But in their view, there's no conflict at all, because we have the jury verdict form and a poll of the jury, and in both instances, the jury said they were not unanimous.
Correct. In both instances, the jury said they were not unanimous, but that does not disprove that they failed to answer any question unanimously. And that's something that the Court of Appeals detailed in their analysis and the majority opinion, and something I think Renda Contracting continues to sidestep. That Rule 226A contemplates this very scenario.
Exactly. Rule 226A contemplates this scenario, and so does the pattern jury charge. And they both lay it out. This is exactly how this should all work, to be sure that the jury's answering unanimously when they need to, and not when they don't need to be. And you check these boxes, and it all becomes very clear exactly what the jury has done. So why wasn't that followed in this case? It's to avoid this very argument that we're having today. That's why the Rules Committee and the Pattern Jury Charge Committee spent the time to do that.
Yes, that's correct. And unfortunately, the record doesn't reflect why exactly it was omitted in this case, why the error took place. I can't point to the fact that the homeowner's first amended charge submitted to the trial court, which can be found on the record at volume 10 of the court reporter's record at 6645, did include a unanimity instruction as to question 8. And unfortunately, the record's not clear as to why that did not make it to the jury. But this is not an example, for instance, of anyone trying to pull a fast one on the other side. I think it's a reflection that in trial, in the heat of battle, there's going to be errors at times. This court has talked about before in its cases that the trial court doesn't always have time to scour every single word or every single sentence. And so in this situation, Renda Contracting has been on notice for quite some time that the plaintiffs were seeking exemplary damages through gross negligence. I think there's a line from the United Scaffolding dissent that's very apt here. Defendants have been on notice since about 1940 of what Rule 79 requires when there is a defective charge submitted, and that's to object.
So if the instructions on question 8 had said, you may choose an amount of punitive damages if 10 of 12 of you agree, and so it's facially out of compliance with the statute, but and they don't say anything, the defense does not object to that for whatever reason, and then the answer is yes, are you saying you get to recover punitive damages despite the facial noncompliance of the verdict with the statute because they didn't object to the charge?
I think that's a much tougher case, but I still think.
Why would that be a tougher case on the waiver question?
I think the waiver analysis would stay the same in that situation, that they failed to object, and so the charge submitted to the jury would be what controls in that situation.
Don't we functionally have the charge that Justice Blacklock posits here, because the initial instructions say, unless otherwise instructed, the answers to the questions must be based on the decision of at least 10 of the 12 jurors. So shouldn't we assume that the jury followed that as to question 8?
This court could assume that based on that.
We have to, right?
Correct. There is a presumption that juries follow the instructions they're given. That's something this court has repeatedly emphasized.
And so then when the judge takes that verdict and is forming it into a judgment, doesn't the judge then have to follow the law? If the jury, if 10 of them said this, no question about that. But the law says that in order to have a punitive damages award in a judgment, I have to have unanimity, and I don't have that.
I think in that situation, the trial judge should still be bound by the charge that's submitted to the jury, particularly when there's never any objection to it.
I mean, there's no question that the jury would have given that answer. They would have gone ahead and instead of ensuring their unanimous agreement to the amount, they'd put the amount in there. And maybe said, yeah, there are 10 of us that found this, but nonetheless, at that point, we now know, what the jury says, but we also know what the law says. So, I mean, instructing the jury doesn't change the law, does it, in a case like that?
Not necessarily, no. Instructing the jury doesn't change the law, but in order for the trial court to set aside jury findings, you need...
Well, it's not setting it aside. It's just saying it doesn't lead to a judgment. It's not setting it aside. It just hasn't reached the level that the law requires for it to be converted from a verdict into a judgment.
That's correct. I still think in that situation, it's incumbent on the other party to raise that issue to the trial court and give the trial court a basis to do so.
Well, let me ask you this. The discussion you had with Justice Bland about the statutory language that says you can't shift the burden of proof. What if the instruction in number 8 had said, you must all be unanimous and you must award punitive damages unless Oscar Renda proves that punitive damages would be improper, and there's no objection from Oscar Renda? What result then?
In that situation, given their lack of objection to the charge, I still think the charge there would control. Even though the statute provides there's no shifting of the burden, there's a conscious waiver on Oscar Renda's part. And I think it's important to step back and look at what you can waive in court. For instance, you can waive your right to a 12-person jury trial under the Texas Constitution. There are
Well, does the Constitution require a 12-person? I mean, can you waive it if the Constitution required it? The Constitution said such and such a case may only lead to a judgment upon a verdict of a jury of 12. Could they waive that, do you think?
Yes, I think they could. And in fact, the Texas Constitution does provide that in a district court you have a 12-person jury. And there have been numerous cases in the Court of Appeals in which, in that situation, it has been waived. For example, Dixon versus J. Weingarten out of the 14th Court of Appeals, as well as Audia versus Hanold out of the Dallas Court of Appeals in 2010. In both those cases, you had a waiver of your right to a 12-person jury.
You have a right to it, but what if it isn't your right? What if the Constitution says, we think, it doesn't say this, we think that a judgment can only follow if there is a jury, not that you have the right to demand it and that right must be respected. In that instance, it stops being something that's just about the parties. And my question to you is, why should we not read the statute, particularly in the punitive damages context, in which, as Justice Bland pointed out, those are not compensation. Those are not personal, really, to the plaintiff. They're a way that the law allows for a kind of civil punishment that's the interests of society. And so if the law says this is the requirement to do that, our courts will not enter into this particular thicket unless this happens, how is that something that is really even waivable?
I think it's waivable because a judgment here with exemplary damages doesn't cut against the interest of justice, in that the other side has had notice of this claim, and when you have notice of the claims against you, you have the burden to object if there's a flaw there. And so in this case, both sides understood what was at stake, that there was potential exemplary damages, and so any error or failure to object on the part of Oscar Renda is their own doing, and not something that goes against the great interest of justice that perhaps something mandated in the Constitution would.
There seems to be two aspects of waiver that you're arguing for. One is the Osterberg line of cases that say that we measure the sufficiency of the evidence under the charge as submitted. But here, we're not measuring the evidence in the case. Is there a case that applies that Osterberg line to the deemed element side of things?
I think applying the Osterberg side to the deemed element, I think even in some of the cases I previously mentioned, such as Burbage versus Burbage, Ramos versus Frito-Lay, even though there were errors in the charge, that was still what controlled any sort of legal sufficiency review in that case.
And then the other kind of waiver that you're talking about is this idea that we didn't necessarily secure unanimity, but you should deem unanimity found because there was no instruction. How can we deem unanimity found when the verdict form reflects that the jury was not unanimous? So ordinarily, a deemed element is an element of a cause or a claim that's missing, and the jury answers everything in connection with that claim along the lines of meeting all the elements, and so we would deem it. But how can we deem it here when the jury hasn't answered everything in line with all of the elements required for punitive damages?
I think to respond to that in two parts. First, to clarify, it may not necessarily be something that needs to be deemed. Just because the unanimity requirement was waived in the first place, it just wasn't required here when reviewing the charge. I pointed to cases with deemed elements found more as, I think, instructive just to the analysis of how this court has looked to cases in the past with a charge defect or something omitting an error. And second, to what evidence is in the record to support a deemed finding of unanimity on 8. I think the best thing to point to would be the instruction to only get to question 8 if you were unanimous on question 7, as well as the answer
Right.
of...
But you could see that a jury that was all in agreement on everything and the underlying liability questions, which I agree with you, we can gather from question 7 that they were, but they might not agree on the amount of punitive damages because punitive damages are different, and some jurors might say, I don't think they're really, I think the amount that we're awarding is not really the amount necessary to deter this conduct. So it is a different question that the jury's answering in 8.
Yes, it is different, but in looking at the verdict in light of the entire context, the jury did give $75,000 to each plaintiff, which seems to reflect some sort of unanimity there amongst the jury. For these reasons, the judgment of the Eighth Court of Appeals should be affirmed.
Can I ask you, before you sit down, I don't think you've had a chance really to respond to the citation of Zorilla. And that case seems pretty relevant, and I don't think it was in your brief either. Do you want to just tell us why you think that doesn't inform our analysis before you relinquish the podium?
Yes, I don't think that case informs the analysis here because statutory capped the damages are something that can always be applied retroactively. And so you don't need the jury there in order to apply a statutory cap to punitive damages. But in this case, when looking at what the jury said and what the jury found, any discrepancy or alleged conflict that Oscar Renda wants to rely on could have best been cured by the jury themselves, and they failed to raise that in front of the jury. So I think that's the distinction there, is that statutory caps can always be applied after the fact, whereas if there's a alleged issue with jury findings, that needs to be resolved in the moment before the jury is discharged. And that's consistent with this court's recent line of cases.
Any other questions? Thank you, Mr. Gray. Mr. Anderson, you have 5 minutes.
Justices, I feel like the issues are all properly joined. I would like to stress the statutory nature of Chapter 41. I believe that it's the province of the legislature to make those requisites, and Texas voters agree. Punitive damages are strictly controlled. The burden of proof can't be shifted, and there's nothing in Chapter 41 that creates some sort of burden of proof for the defendant on punitive damages. I think that this is already clear, but I would like to point out that the Red Wine versus Peckinpah case does, to me, resolve completely the 301, Rule 301 component of the purported waiver. You asked some very poignant questions on 295, and I've given you my best answers. But if there is something that a remaining question that I can address.
I want to know if you think the statute protects defendants from themselves. For example, if a defendant were to literally agree to an instruction that says, if 10 of you find punitive damages will be awarded, and no objection to that. In fact, an express consent to it. Do you think the statute nonetheless would say, too bad, you didn't get unanimity?
No, I don't think that the statute would protect a defendant in that situation.
So is that our job now is to decide whether or not that's the situation that we're in this case?
I think that Renda's case is strengthened greatly by the fact that in this particular instance, very rare, all the stars align, where the burden of proof, again, at each turn falls on the homeowners. And I think that the overall scheme of Chapter 41, and as well as Justice Alley and Justice Green, certainly in his dissent, joined by 3 in Menchaca, I think that there is a lot of pull to it.
A lot of?
That it has a lot of traction.
It seems that your position hinges on there being a difference between intentional knowing waiver of a right, which I think you just said would allow a verdict that was not compliant with the statute. A difference between intentional knowing waiver and on one hand, and then on the other hand, the kind of waiver we talk about when we just note that there was no objection, there was no argument. Therefore, we call the issue waived, even though there may not have been an intentional decision to waive it. You think that's what it comes down to?
I think that's a pretty good analysis, Your Honor. I think that at the end of the day, that Chapter 41 it goes beyond just the elements of the charge and an admitted element. I do need to research that some more, and I will do that. But yeah, in a nutshell, I think that Chapter 41 is intended by the legislature and the voters to protect defendants in a different way, in a statutory, in a scheme that is pretty comprehensive as you look at all the various components.
It seems to me that would be answering the question differently, because it sounds to me like what you're saying is the answer to this depends upon the nature of what was being decided by the jury. And then isn't that going to really open up a can of worms with regard to our jurisprudence having to do with the duty to object to charge error, depending upon what the cause is or whatever the issue is that's before the court? or before the jury?
I think that the 41003 means what it says, and that is that there is no burden of proof on defendants, and that in order to obtain punitive damages, you very clearly have to have definitive, affirmative, certified answers to all three of those issues. And I don't think that the court should guess defendants into that situation.
So that would apply to other issues where there's other statutory directives that's similar to that, right?
Well, it would depend on the purpose and tone of the statute.
Any other questions? Thank you, Mr. Anderson. Case is submitted. That concludes the arguments we had in the cases this morning. Again, court is pleased to be able to hear our argument in cases in El Paso. In just a moment, we'll return to the bench here and give you the opportunity to ask us questions about the court and its operations, and we'll be able to share with you that way for several minutes. But for now, we'll ask the clerk to adjourn the court.
All rise. Oh yay, oh yay, oh yay. The Honorable, the Supreme Court of Texas now stands adjourned. cases that are pending before the court. So if you wanted to ask them a question about a case they haven't decided, they're not going to be able to answer your questions about that. But if you have questions about the process, about how to become a lawyer or a judge, things like that, we'll welcome those questions. I think the court is ready to come out.
Well, for the next few minutes, we're anxious to hear your questions. I'll just say a word about the process that you've seen. Texas, like most states and the United States, has 3 levels of courts. Trial courts where cases begin. And you saw in the first case, a case that began in the probate court. In the second case, a case that was tried to a jury. And then any party in a case that starts in the trial court can appeal to the Court of Appeals. That's the second level of courts, and are entitled to a decision by that court. They can also seek review in the Supreme Court, only we have discretion to hear the case and decide it or not. And the guiding principle in the Constitution and our statutes that we follow is that the case should be important to the jurisprudence of the state, to the state law, to the development of the law in the state. So we don't hear every case. We hear cases that we think are going to be important to the development of the law. We read cases every week. If anybody wants to talk about a case in one of the 9 of us, they can. And then we will. And then when 4 of us believe that we should hear the case, just like you've seen this morning, then we schedule oral argument. And after that, we talk about the case for the first time. So as we sit here this morning, we have not talked about what we think the results should be in the 2 cases that you've heard. We don't know yet what each other thinks about that. And we talk about that once a month. For these cases, it'll be a week from Tuesday. Then after we decide, the court has to explain its decision in an opinion. And so one of the members of the court is assigned to write down the reasons why the case is being decided the way that it is. Sometimes we don't agree, and when we don't, judges who do not agree with that decision can write separately in a dissent or concurrence and explain a different reasoning about the case. So that's where we are in the process of the case. Our practice is to decide all cases that are argued after the 1st of September, and usually we quit arguments about April sometime, to decide all those cases by the end of June. So we'll decide these cases, just like all of our cases, as soon as we can, but in any event, by the end of June. So that's our schedule for these cases. That's kind of where they fit in the court schedule. But we're happy to take questions. I believe microphones are set up, so let's hear from you. Over on, is there somebody? Yes.
First of all, I wanted to thank the court for coming to El Paso and allowing us to see the court in process when normally we wouldn't be able to. And second, I wanted to ask any advice that the court would have for an aspiring attorney or judge and what we should do, what undergraduate you would recommend us following, even though you can get into law school with any undergraduate, and which law school you would recommend going to, and any advice. And any advice you have on either being qualified, making more skills, or just improving yourself in order to become a capable and skilled attorney or judge.
Justice Flaherty?
Well, of course, I would say that the school you need to go is the University of Texas, because my blood is burnt orange. But just joking. Really what you need to do as an undergrad, verbal skills and written skills, the ability to write well, to express yourself well, is very, very important for a lawyer. You really, it's a necessity. You're going to have to do that. So a really good thing to focus on are classes in English, classes in rhetoric, classes in those types of things, in writing, to improve those skills to the extent that you can. Always, of course, remember that, you know, going to law school is it's a rigorous process, and so you need to prepare yourself for that now, and work really hard, study hard, make good grades, because it's difficult to get into law school for a reason. And so the things that all of you know, and you've known all your lives, and that is just really work hard, do the best you can. Certainly other things that are good to major in would have to do with things that have to do with government and those types of issues, maybe not majoring in it, but certainly having an understanding. One reason that we love to come on these trips, we try to do it twice a year. During the pandemic, we were not able to do that. This is our first trip since the pandemic. But the reason that we love to do it is to help educate the public about civics and the importance of civic education, and to help understand that these, I hope that you could tell from the cases today, that these are not, you know, arbitrary cases that have to do with something way out there that doesn't affect people. You know, these cases are things, these cases today, for example, have to do with regular people that are dealing with probate issues and trust issues and damages that could come about because of some allegation of something, that somebody has done something that they should or shouldn't do. So they're real things that affect everybody in this room, and hopefully you can see that it's done in a very fair manner, very objectively, very professionally. None of us have I'm very proud of our court. We don't get on a soapbox and start, you know, making proclamations about this or that. We really study the law, and we do our best, even though we don't always agree on the correct application of the law. We work very hard to get there. I hope that answers your question.
Yes, ma'am, it does. Thank you very much.
I want to repeat again, thank you very much for coming down to El Paso. We're very appreciative, and we're giving you a big abrazo, as they say in Spanish. My question involves the 15th Court of Appeals, and because there's been a lot of anxiety and curiosity about that, and certainly how the Supreme Court will handle that issue. Any thoughts?
I'm not quite sure what there will be to handle. We were here a couple weeks ago, thanks to your local bar association, and we're able to present kind of where we are currently in terms of the new business court it's a statewide trial court level, and the 15th Court of Appeals. There's an agency within the judicial branch of our state called the Office of Court Administration, and they do lots of work for all of our courts in different ways. And one of the things they've been doing is working very hard to figure out how to implement this new 15th Court of Appeals. All the 14 courts of appeals that we currently have are geographically distributed around the state. So the El Paso Court of Appeals, I see we have at least, well, we've got all three of our justices of the El Paso Court of Appeals, the 8th District Court of Appeals here with us today, and they cover a region that includes El Paso, and then there's Austin and San Antonio and Waco and Houston and so on. The 15th Court of Appeals is different because it will have statewide jurisdiction, but only over certain types of cases. the cases that come out of these new business courts, the trial courts that will handle these big complex business disputes, and then cases that involve administrative agencies within the executive branch, think Department of Insurance, Health and Human Services, and so on. They have administrative powers that give rise to disputes that can then go to the courts. And many of those kinds of cases involving the state and its agencies, those appeals will go to the 15th Court of Appeals as well. So step number one is just setting them up, and that's what OCA, the Office of Court Administration, is working very hard on to do right now. Real interesting concept is that some of these courts may be set up within law schools around the state, which would be a very interesting kind of partnership to have the courts there right in a law school. And so setting them up also involves appointing people to sit on them. And the governor's busy doing that. There was just an article this morning that I saw that listed a bunch of the names of people who've applied for either of those two kinds of courts. And then it's just a matter of getting those people in and having the rules in place to govern what happens in those courts. And we are responsible for adopting those kinds of rules. And we've been very busy doing that. So we're very hopeful that it's all going to come out smoothly when it all gets implemented starting towards the end of this year. So I don't know if there was something more specific about it than that that you were asking for, but that's about all I can say about us handling the 15th Court of Appeals.
No, thank you very much. That's a great thumbnail for us.
Great.
Bienvenidos. Gracias. Welcome and thank you for coming down to El Paso. I'm Alejandro Rodarte. I'm a UTEP student. And even though I'm not a law student or prospective law students as those behind me, I do find it very important to keep up to date, not only with the court, not only with the law, but as politics as a whole. So my question may not exactly be in line with those ahead of me and those before me, but I was wondering to ask the court, and I was hoping to hear your opinion on this, that we are in a very politicized day and age where it feels like everyone has to have an opinion on something, and I feel like most of the times it's more important than not to have that opinion. And I was wondering, how does that affect your jobs? How does that affect your decisions? Especially on a college campus, I see people that are very engaged and it feels like they're at a loss when it feels like their engagement doesn't transfer to great change. And I feel like a lot of people are wondering why that happens. And I'm thinking about, how do you see that problem? How do you see that change?
Well, thank you for that question. It's a very timely question, and we are all human beings who are aware of the same things that you are aware of going on in the world. But we have all sworn an oath to preserve, protect, and defend the Constitution and laws of the United States and of the state of Texas. And I'm proud to say that everybody on this court goes about the business of deciding cases solely on the basis of our best honest assessment of what the law is, without regard to politics, without regard to our personal sympathies. That is the job that we have sworn an oath to do. And I'm proud to have colleagues who approach their job that way, and I do my best to approach my job that way every single day. Our decisions are, of course, subject to disagreement and to political discussion in some cases, and they're the topic of news, and that does not affect the way that we make our decisions. But let me say this. Criticizing the government, including criticizing the court, is your constitutional right. It is your God-given right to question what your government is doing, including to question what your courts are doing. But with that acknowledged, I'd ask you to, when you're criticizing a court, do it in this way. Decide what you think the court should have done based on the law. And if you disagree with the court on the law, then your legitimate criticism, your disagreement with the court's decision based on the law,
absolutely has a place in our conversation about how we should interpret our law and how we should live together as Texans. What I hate to see is criticism of the court suggesting that the court is doing something other than basing its decisions on its honest assessment of the law. Those criticisms are not fair, and those kind of criticisms, even though they're people's right to make if they choose to, those criticisms undermine the public's confidence in what the court does. And with respect to this court, those criticisms are entirely misplaced. But thank you for that question.
Thank you as well. Again, I just want to thank you, Court, for coming here to El Paso, Texas, and allowing us to view one of your sessions. That is very amazing. And as for my question, I understand that when looking through multiple cases, you have different type of thoughts, you have different type of questions, and overall, things would change between the cases. So my question really is, what exactly is the thought process you go through when you're hearing a case, and whether this thought process is consistent with your other cases that you have to hear or not?
Sure. Well, as the Chief Justice mentioned, first of all, we're thinking about, is this a case that the court should hear? We get about 1,000 petitions a year to decide where people are asking us to hear a case, but we usually hear about 10%, about 100 of those. And so our thought process first is, what did the Court of Appeals, because all the cases that come to us, one of the courts of appeals has seen it first, and a trial court. And so our first thought process is, well, what are the arguments that the people are raising in the case about why the Court of Appeals was wrong? Do we agree with that or not? Do we think that's consistent with what Texas law actually is? And it could be on an issue of substantive law. You heard some of those argued this morning about, what does trust law require? Or what does a particular statute require as far as how many jurors have to answer a question, yes or no? It could also be on a procedural issue. You heard some of those this morning as well about, do you have to raise an objection at a particular point? So we get both of those kinds of issues, and that's really our first call is does it look like the Court of Appeals may have gotten one of those issues wrong? And then also beyond that, it's not enough just to say, well, the Court of Appeals was wrong. It has to be, as the Chief said, important to the jurisprudence of the state. So is this an issue where it's not only wrong, but it's really going to cause a problem for courts around the state to try to apply the law fairly so that we get similar outcomes in different parts of the state? Because what you really don't want is to have a court in El Paso and a court in Texarkana following different rules and applying them to the same kind of case, because that's not fair to the parties that are involved in those cases. And so we may look at things like, have other courts of appeals around the state disagreed? Do they see this issue differently so that the Supreme Court needs to step in and settle it for the whole state? By the same token, is this an issue where even if courts of appeals haven't disagreed, it could cause a lot of confusion or be something that we need to be clear about what the law is, because that's very important to all of us, and I think that's part of our obligation, because the government owes it to its citizens to be clear about what your rights and obligations are so that you can govern your conduct accordingly. Because it's not fair to expect you to follow the law if you don't know what it is. And so one of the things that we can do is try to help be sure in the cases that we do decide that we explain the law in the way we're not making law in most of our cases. We do have some common law jurisdiction. A lot of times we're interpreting something that the legislature has made the law on. And if we can explain it in a way that's clear so that everybody knows what their rights and obligations are, that helps uphold the social contract that we all have among ourselves and with our government, so that everybody knows what their rights and obligations are and can be treated equally and fairly held to those obligations. So those are some of the thought processes that we go through in deciding whether to take a case, and then also when we're deciding the case. Again, as Justice Blacklock indicated, we've taken an oath to decide the case based on the Constitution and laws, so it's really just a question of what the Constitution and laws require in a particular case that's before us, not what our personal views are, not what we wish the legislature might have done, because if the legislature has spoken, then people who disagree with that can go and talk to their legislators. They may want to vote for a different legislator the next time if they don't agree, but it's not our role to change the legislature's judgment unless they have somehow violated the Constitution that it requires them to act in a certain way. So those are some of the questions that we think about in deciding which cases to hear and then how we're going to write about the cases that we do hear.
All right, thank you.
Good morning, Senate members. Like the people in front of me, I would like to thank you for visiting El Paso, Texas. My question would be if you can give me your insight or thoughts of the implication of the immigration laws coming from, we are a border city, and if you can tell, if you look right out the window, we can literally see the border of Mexico, and if you give me insight of the immigration laws.
Good morning, and thank you for being here. Thank you, all of you, for your incredible attentiveness this morning. It's sometimes hard to follow our arguments when you haven't had the opportunity to read all the briefing and do all the study that we've done. And even though you're some distance away from us, so you could potentially get away with whispering during argument, no one did that. So thank you so much. Your question about the immigration laws is an interesting one because immigration, by and large, and the law of immigration is taken care of in the federal courts. So Immigration and Customs Enforcement, for example, is a federal entity, the Department of Homeland Security, a federal entity. So most of the law that develops around immigration law happens in federal court. And so we are the high court for the state of Texas, but obviously the Supreme Court of the United States is the high court of the United States. And so many immigration cases go through the federal courts. That's not to say that issues surrounding immigration have a lot of impact in the state courts. Why? Because whenever you're looking at human relationships with people that are here and residing in Texas, you're going to have family law disputes. You know, where is this child properly, you know, who should have proper custody of a child? That would go through the family courts. There can be collateral consequences in the criminal courts about if you are convicted of a crime and you're undocumented, what is the consequence on your immigration status? Are you immediately deported? So and then of course, just in general, with a person's right to assert a personal injury claim, you know, so it's not that immigration law doesn't impact us. It impacts us every day in the state courts, but we're not the ultimate authority on the law of sort of entering the country and legal status. That's through the federal government.
Thank you.
Hello, I would like to thank you for coming to El Paso, and I have a specific question for Chief Justice Nathan L. Hecht. I'd like to ask, how would you describe your journey, like becoming the Chief Justice of the Texas Supreme Court?
Great question.
It was, I never planned on it. I was very happy practicing law. You asked questions earlier about what do you need to do. First of all, I'll just say to you, you can be a lawyer. It doesn't have to be in your background. My dad was a farmer in New Mexico, in a small town in New Mexico. I had no lawyers in my family. But when I was in college, I decided that was something I wanted to do and enjoyed practicing law. And one day, an opportunity came up for me to be a trial judge, and I'd wanted to do that for a long time. I just was kind of waiting to see if it would happen, and it did. And I enjoyed being on the trial bench a lot, and on the Court of Appeals up in Dallas for a while. And then, again, an opportunity just came along for me to run for the Texas Supreme Court. Of course, in Texas, we elect our judges at all levels, as you know, in partisan elections. And so I stood for election back in 1988 and was elected to the court, and have enjoyed it very, very much. It's an opportunity to not only work on hard cases that we get as a court, but also to help make the courts of Texas more responsive to you as consumers, as people who are interested in the justice system, who have cases from time to time, and you want to make sure that they're handled correctly. So we have an opportunity on our court to help administer the other courts in the state and see that they run effectively and fairly, and handle cases in a way that it improves trust and confidence in our court. So that's kind of how I got there. I can't take any credit for it. I happen to be standing in the right place at the right time. But it is something you can prepare for in your studies, in preparing for law school, and in kind of looking down the future.
Chief, you had the same idea I did. Go ahead. I should say, by the way, Chief Justice Hack gets a lot of his decisions wrong, and I write a lot of dissents explaining why he's wrong, but I never, not a single day goes by that I don't lose the remarkable appreciation I have for the fact that I get to sit on the court with Nathan Hecht. You guys need to understand, when your children are learning Texas history, anything mentioned about the judicial system in Texas for the next 100+ years, the star of the story will be Nathan Hecht. He has served on this court since 1990, January 1, 1990. Which means before many of you UTEP students were born, before most of us became lawyers, the rest of us. He signed the law license when I became a lawyer, and I guess everyone except Justice Lehrman. She's a child prodigy, is the only reason why. But he signed all our law licenses. He is the longest serving member of the Supreme Court of Texas in the history of the state or Republic of Texas. So you guys need to, I just want to make sure that it's not lost on you the privilege you've had to be here today. This is his last year on the court. Under our Constitution, you age out at a certain age, something like 50, I guess we'll say. And so as by the end of this calendar year, he will be constitutionally required to retire. And we hate to see that. There's one thing we are unanimous on, is we hate to see that. But I just wanted to make sure you understood that you got to be in the presence of a great Texas legal legend here this morning. Well said.
We have just about 10 minutes remaining in this question and answer session. Hopefully we can get to everyone who's in line. Go ahead, sir.
Thank you. Good morning, Justices. Again, I'll thank you for coming to El Paso, as I'm sure you're already bored of hearing, but we really do appreciate you coming here. I have more of a procedural question. I was wondering if you have any insights on how you weigh black letter law against the spirit of the law, especially with unresolved issues, as you all hear constantly, and with facts that might not be within the and with issues that might not be within the law yet.
So it's a good question. Before I get to it, I want to say We are not getting bored of hearing thank yous. I have the privilege of being a native of El Paso. This is my hometown. So the court strip here has been very meaningful to me, and I've been looking forward to it a long time. Despite all of that, I did not really know a lot of the details of how this was all going to work about last night. And I have to say that I want to thank you, because every person in this room has done just a tremendous job of making me so proud of the warm welcome and the really tremendous spirit that we've received from everybody here. So thank you. You made El Paso proud again. To your question, so the spirit of the law is something that I read a lot about in law school. Now that I'm here 20-something years later, what matters to me, how I guide every decision I make is by the words that are written on the page. So I worry about what the words actually say, and that's being a textualist, which is today, I would say, the very prevailing philosophy and approach to interpreting whatever it is you're talking about, whether that's the Constitution, a statute, a contract, a will, lots of different places where you apply that approach. But I think there's a really good reason that approach is the prevailing one. And that is that the words that are written on the page, the text, is the very best evidence that anyone might have 1 year later, 10 years later, 2 centuries later, of what was going on when the parties wrote the contract, when the testator wrote the will, right? And so it is the way to be most faithful to what the person creating the legal document meant to have happen. And isn't that the point of our justice system overall, is to allow people, contracting parties, whoever it is, the voters who elect representatives and then have representatives come together to pass a statute? Isn't that the point? It's to really get at the core of what they meant to say, and what better evidence of that is there than what they actually said. All right, so that's my approach. There are times when you have an ambiguity in a text where the doors sort of open a little more to consider context. So we never look at the text in isolation. We consider the whole body that we're talking about, whether that's an entire contract. You wouldn't just look at one little paragraph, you would look at the entire thing. Same thing for a statute. You wouldn't just look at one line, you would look at the entire thing to try to make more sense, because words need context to have their very best meaning. So that's always appropriate, to consider context. What we try to stay away from in almost every situation in the law, there are some exceptions, like when there's a true ambiguity. Then you might consider sort of business practices that were prevailing at the time, thus and such. But for me personally, the text is the best guide, and therefore my guide.
Thank you.
Hello. Thank you all for coming to El Paso. It really means a lot to all of my peers and I especially. It feels very special and an honor. I'd like to cater my question specifically towards the women in this honored court. I know that as a minority representation of women in any leadership position, there are some unnamed hardships and unnamed sort of trials that women representation is met. And I would just like to get your guys' feedback on how you have passed through it and to where you are now.
Justice Young?
The question was for the women.
I can't wait to hear how he answers this.
I have some deep thoughts on this, Chief.
Not Justice Young. Justice Lerman. Sorry.
And so, I'm sorry, so what is your specific question about how we have dealt with challenges? Is that what you're saying?
Yes, more specifically, it's a layered question, sort of. I'm sure that, or I hope not, but I'm sure that you guys still have some trials, still have some judgments taken even in your position about being a woman. And so what are some things that you have taken away from those experiences and that you could share?
Justice Bland?
So, everybody, that question earlier about what law school should I go to was interesting to me because when I think about students deciding where to attend college, which I think is going on right now this spring, I tell the students that law schools have all kinds of incredible things to offer. Any law school you go to is going to have great professors, great clinics where you can get real world experience, opportunities for engagement in Texas and across the country. But there's only one of you. There's only one of you. And wherever you decide to go, they're going to be so lucky to have you because there's only one of you. And when I think about whether, women encounter obstacles, and surely they do. Everyone in their career, in their family life, encounters obstacles. And in fact, sometimes I like to just go, obstacle, 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 because everyone encounters them. But, that's part of the satisfaction of the journey is to kind of go obstacle. And to, so I wouldn't say necessarily that anybody's journey is obstacle-free. But to the extent that, you can look at someone and say, wow, she did it. So maybe I can too. That's great. If it provides that incentive, like, Hermione and the Time Turner, and Harry saying, well, I knew I could do it because I did it. And so, to give you the confidence to go somewhere, that's great. But it's really important to see people as unique individuals, all of whom are encountering their obstacles.
Yeah, I'll just add quickly, thank you, Chief, that one thing I've learned over the course of being in this profession is that you have a lot of control over some things. There are plenty of other things over which you have no control. And so what I have found to be good sort of advice for myself, for others, is to say, do all that you can to control the things that you can. And so what is that in the context of being an undergraduate student or being a law student or being a new lawyer or being a new judge? That is, work as hard as you can, be competent so that be prepared. And that's what you can do. You can control how well you perform. You can control how hard you study. You cannot control what every other person in the world thinks about you, right? Maybe over time, the person who didn't give you the benefit of the doubt at the outset may be persuaded by your tenacity, by your hard work, by your competence. And that's a win. But I would say it's best to let that happen, if it's going to happen, somewhere else besides your own mind, because you ought to be concerned about doing your best and not about how other people perceive you.
Yeah, and thank you for that question. When I was in law school, about a third of the law student population were women. And soon after I graduated in the late 80s, that went up to 50%. And I think that's what's happened over the course of those years, now quite a few years, is that women are very good lawyers, as it turns out. I mean, I think all the guys here would admit that. And the women know it. But And people have seen that within the profession. And because of that, a lot of the challenges that existed prior to any of our time really are not there as much. So, for example, the first woman justice that ever served on our court, Ruby Somdock, she graduated from SMU, #1 in her class, but she couldn't get a job as a lawyer. She had to work as a secretary. That doesn't happen anymore because women have proven that they are very good at this. And that happens in a lot of professions. So the good thing is that we have a lot of women that have preceded us that we need to thank. And much like wonderful Justice Hecht, we have many women who've been trailblazers that have done really good jobs, that have made it easier for all of us. And for all of that, I think all of us, men and women, are very grateful. So thank you for that question.
Thank you.
All right. So thank you once again for coming to El Paso. We appreciate your visit. And I have a question. It's in general towards like the function of being a justice. What were some of the obstacles that you guys generally encountered when first starting off as a justice in the Texas Supreme Court?
You can answer that one.
Now, Justice.
All right. Well, thank you all. I think I can speak on behalf of all of my colleagues that the warm welcome that each of you have expressed is deeply felt. This has been a wonderful trip already. You all are wonderful. Muchas gracias por el abrazo, señora. Y un abrazo para ustedes también. I'm so glad also that there's so many students here who have stayed. Justice Bland pointed this out, that these cases, I mean, you're not deeply versed in them. Man, they might have persuaded a few of you who thought that you're going to become lawyers to say, well, not anymore. I hope that won't be a reason if that did affect you. If you thought, I don't really know what they're talking about. Of course not, because you didn't have the chance to read all of the briefing. You haven't gone to law school yet. But I would agree with what some of my colleagues said. Every one of you who wants to do it can do it. And if there's a reason you decide not to do it, let it not be because hearing court in session just sounded too crazy. So I look forward to seeing a whole lot of you one day at the podium making arguments to us and to our colleagues on the 8th Court of Appeals and our colleagues on the district and county courts here in El Paso County and all across the state. I'm the newest justice, so your question's really good. I'm the baby one here, as you can probably tell. When Chief Justice Hecht, who I agree with everything Justice Boyd said and more, when he first became a judge, I was 4. And I'm not that young, right? So you can, even though that's my name. And so I'm the new guy here. I've been here for 2 years and a few months. He's been a judge for every year that I've been a judge. He's been a judge for much more than 2 decades, I guess. It is hard to join a court where you so deeply respect your colleagues. You have argued before them, as I did many times, as a lawyer, and try to take a seat at the table and feel like I probably don't really belong here. Have any of you had that experience of being in something where you've gone on to the next stage and thought, gosh, I'm not sure that I belong. Somebody's asked me to be here, but maybe they were wrong. That's an obstacle that is in one's own mind generally. And the solution to it usually is to work as hard as you can, to do the best you can. And as a judge, we take an oath. It's pretty simple. We promise to protect the Constitution, to do what Justice Blacklock described. When we get a case, we have one thing that we're looking towards, and only one. What does the law require? And we promise not to like the decision that we render, but we promise to make sure that it is the best and most accurate decision that we possibly can. And so that obstacle of coming to this group of people that have been friends and people that I've admired from afar for many, many years is also the single best solution to it for me, because they were all so welcoming, just like you all are so welcoming. From within a few hours of the governor announcing that I was the new appointment, every single one of these justices had called me and said, how can we help? What can we do? We're so excited to have you, and they've been so encouraging as I do my best, make my little mistakes. I'm the baby justice. I'm taking baby steps, doing my best, But I can tell you that when you're in a group of people, even when you feel perhaps, gosh, maybe I don't fully belong, usually the people in that room want you there and are going to do their best to help you. And if they don't, well, forget about them. They're not the right people for you to be looking to. And all of my colleagues have been the ones that wanted to make sure that each one of us, not just me, but each one of us can do the best we can because we have that common goal of getting the law right on behalf of all the people of Texas every single day in every single case.
Oh, I could just take it off. Okay, cool. I'll keep mine rather quick. Hi, actually, I wanted to introduce myself. I am Fernando Guerra. First, I want to give you thanks for coming here to the University of Texas at El Paso. How is the weather like here today? Is it good?
Beautiful.
All right, sweet. I know. I'll keep mine rather quick. I know sitting here for about 2 hours is not easy. But mine is not really regarding more about the law. I think I'm a little bit underqualified to kind of know what I'm talking about there. But however, I wanted to see if I can get your guys' support. I'm actually part of an organization in partnership here in the University of Texas at El Paso. It's an organization with a World Mission Society, Church of God. We are ones who believe in Heavenly Father, Christ An Sang Hong, and Heavenly Mother, New Jerusalem. And we are university students that are actually scattered around Texas. And since you guys are here, I wanted to see if I can get you guys' support when it comes to volunteer service. I don't know what guys' perspective or what you guys do for volunteer service and how we can get your support. I do have some brochures if you do want to go ahead and get a little bit more information about us and see if you guys want to do in partnership or help us out when it comes to this.
I'll be happy to get that information from you and share it with the court.
And let me say, we appreciate your passion for your faith. The freedom of religion was one of the foundational freedoms for which this country came into existence. And although I don't know that the question was particularly germane to why we're here, I want to acknowledge that we respect your faith and your desire to speak it, and that applies to everybody in this room, faith or no faith.
All right, thank you so much. Hope to see you guys from here soon. Thank you so much.
All right. So our final question here.
One more.
Hello. First, I would like to express my gratitude for you all taking the time to be here today. It truly is an honor. I'm a student here at UTEP. My name is Isabella Molina, and my question for you is, when you are hearing a case, what are some determining factors as to if you want to render the decision or remand the case?
Was it render or remand? Is that what she said? Deciding here.
Ask us again.
Did you say, how do we decide whether to render versus remand?
Yes.
Okay.
Well, we mentioned during the arguments that there are a lot of considerations that go into that. If it's easy for the courts from which the case came to render a judgment and be done with the case, or easy for us to do that, then we usually render or direct the lower courts to render judgment. A lot of times it's not, so the case comes to us. There's still other issues that didn't come with the case here that are still pending in the Court of Appeals or maybe in the trial court. And so they should go back and be decided there. Sometimes, and this is really important, and again, we mentioned this in oral argument today, but the appellate process in the legal system is a very deliberative one, and in I would say all the cases that we agree to decide, the answer's not clear. It's almost always there's some question about it. And so when that's the case, otherwise we wouldn't be taking it. If it's easy, then the courts should have decided it correctly, and that should be the end of it. But if it's difficult, there are multiple sides to the question, and you want to hear what other people think. There's multiple ways to look at statutory instruction that statutory language that Justice Huddle referred to. So the more input that you can get on that, the better. So a lot of times we'll ask the Court of Appeals, we'll remand the case to ask the Court of Appeals to take another look at other issues in the case, or maybe even an issue that we just don't feel like we should be deciding without hearing what other people say about it first. And then, of course, lots of times cases have to go back to the court, to the trial court, for the parties to continue to make arguments and for the case to be resolved. It's always a priority to try to get to finality as soon as you can, because the justice system costs money, and we understand that, and takes time. And so parties are interested in getting a quicker decision and one that's firmer sooner. But sometimes it just is, it's more important to remand the case.
Thank you.
Thank you.
I just wondered, since that was the last question, Chief, if I can say something I should have said earlier. And by the way, thank you all for how welcoming you've been, and you make us feel important and hardworking, and like all of you, we like to feel important and like people think we work hard, and so thank you for being that kind. But what I should have said earlier, in terms of the importance of the job and how hard it is to do within our judicial system, we're not the only court, and your local trial court judges, your district courts, your court of your county courts and county courts at law, probate courts, those judges are doing hard work that is essential to the job. And then, as the chief said, in the middle, between those judges and us, are the courts of appeals all around the state. And I alluded to them, but I should at least introduce Chief Justice Jeff Alley, Justice Gina Palafox, and Justice Lisa Soto, who are your three El Paso Court of Appeals justices who work as hard and do as much important work as any of us do up here, as well as three of their staff attorneys who are here as well. I think y'all should stand up and let us appreciate you as well. Both of the cases that we decided today are cases decided by this court, so we're kind of grading their papers here today. The lawyers got to argue that they got it wrong, and actually, I think in one of the cases, two of them didn't agree anyway, so it's kind of them to have to sit here so patiently through this and hear these arguments. Very glad you were here today. Thank you.
And I also would like to just say one thing to point out with regard to the question about women. We have former president of the State Bar of Texas here from El Paso, Sylvia Firth, who has really done monumental things for our profession in the State Bar of Texas. So I think we should also recognize her.
All right, that includes our question and answer session. The court's going to take another brief break. We'll be back to take a few pictures here. We want to thank everyone for coming out today, and let's give the court one last round of applause.